Hello, viewers. Welcome to another episode of Immigration for All, presented by Nora Global and powered by Khulna Tech. For today's session, I'm your host, 𝗜𝟐𝟰🗰🗏🗏🗏. Thank you for joining today's session. And for today's live session, we would like to welcome our principal guest, Mr. Raju Mahajan, the founder and principal attorney of Raju Law. Hello, Mr. Mahajan. How are you?
Thank you very much, Urchita, for inviting me in this show. I'm good. How are you?
I'm great as well. Thank you. Viewers, for today's session, Mr. Mahajan will enlighten us on a very interesting topic that is how to port or retain an I-140 priority date. Before we dive into today's topic, I would like to remind you that if you have any question or comments, feel free to share them with us through the comment box or via email. So I would like to invite Mr. Mahajan for enlightening us on today's topic. Thank you.
Thank you very much, Urchita. Yeah, I would like to see the PowerPoint. All right, thank you. So today's topic is a very complex topic. We are going to, I divided into two parts, part one and part two. So today we are going to talk about part one. And next Monday, this time, we're going to talk about the part two. And before I, go to this topic, I just tell you that, as I said, this is a very complex legal matter. So many of you may not understand it properly without proper background about, priority date and how to port or retain. So if you do not understand anything, that's okay. Do not feel bad. You have to, get some more information, more knowledge about immigration law. Then you'll probably better understand it. So but I'll try my best to explain uh, as easily as possible, keeping the knowledge as it is. And also, another thing is, by the way, this video, we do live in Facebook, YouTube, and LinkedIn, but also this video is the audio part of this video is available as a podcast. So when I say next slide, our podcast audience may feel bad. Do not worry. Anything that is in the slide, I read it, so you're not going to miss anything. So even though you're not watching the video, you're just listening to the audio, you're not going to miss anything. I will make sure that in my audio. All right, next slide, please. All right, so before I talk about this, the first question is, what is port or retain a priority date? As I said, it's a very complex matter. So, please try to focus as much as possible. So an adjustment of status applicant whose application is based on a particular immigrant category can request to change the underlying petition to another one if it is beneficial for him or her. So what it means is sometimes we have multiple applications, multiple petitions for us. So let me give you an example. Let's say 10 years ago, I came to America as an international student, and after my graduation, I got a job, and I was employed by company A. And my PARM was approved, my I-140 is approved, and since then I'm waiting. Let's say I was born in India. That's why I could not apply for adjustment of status, which is the third step for employment-based immigration. I could not apply for the third part because there's a long waiting period. Many of you know that. And later, another company B, they applied for PARM again. Or let's say I applied for EB1 self-petition or NIW self-petition. I applied for I-140. I also have I-140 approved. And I have a new priority date. So here, there's two approved I-140, and both of the approved I-140 have two different priority dates. So in this scenario, you can use your previous approved I-140's priority date for the benefit of the second one. Meaning, many of you know that priority date is a kind of like, it's a serial number. In American immigration system, there's a long waiting period, and you get a serial number. So priority date is a serial number. You can use your previous priority date, previous serial number in a new application if you are eligible. So that's like the easiest way to say that. I'm pretty sure it still sounds a little confusing, but that's the easiest way to say that. So Again, if you have multiple immigration petitions, and that can be I-140, I-130, I-360, if there's any approved immigration petition, you can use your oldest priority date for the benefit of the newest application. That's like the easiest way to say that. All right, let's go to the second slide. So let me give you some examples so that you understand what I'm trying to say. So let's say an applicant who originally applied for adjustment of status. By the way, AOS means adjustment of status. An applicant who originally applied for AOS based on a pending or approved employment-based petition and later married a US citizen now prefers to adjust based on a family-based petition filed by the new US citizen spouse. So what it means is, let's say you came to America under H-1B or a student visa, you are employed by a company and the company applied for your perm-based immigration application and you had a priority date, and later you married a US citizen and now you want to apply for marriage-based, family-based immigration green card application. You can use your previous priority date if that is beneficial to you. If it is not beneficial, then why you'll do that? It's not necessary. But if it is beneficial for some reason, you can definitely do that. Another example, an applicant who originally applied for adjustment of status as the spouse of a US citizen, but now prefers to adjust under an employment-based category in order to avoid the conditional residency requirement. So the second example is the exact opposite of the first example. Here, you applied, your first application was a family-based application based on your marriage to a US citizen. However, now you prefer to adjust under an employment-based category because, in the marriage-based application, there is a conditional residency requirement. And also, anytime a marriage can, break up, you can get divorced. So anytime you get divorced, your marriage-based application get void, immediately you get divorced. So there are some risks, there are some limitations. Of course, there are also some benefits too, but there are some risks and limitations. To avoid those risks and limitations, you can prefer employment-based categories. However, you can retain your previous priority date if the application is still pending. So there's some restrictions, there are some limitations, but it's possible. Next slide, please. Now I'm going to example number 4. An applicant who applied for adjustment of status concurrently with a pending employment-based petition in one preference category and subsequently had another employment-based petition filed by a different employer in a different preference category. So let's say you came to America a long time ago and you applied for NIW. Many of you already know about NIW and your I-140 was approved. However, you could not apply for the second part, which is adjustment of status, because let's say you're born in India, China, Mexico, or Philippines. There's a long waiting period. Or even you're born in like a Bangladesh, Nigeria, Ghana, but there's like a shorter waiting period, but still there's a waiting period. Later, you applied for EB1. It's still self-petition, and there is not so waiting period. You can file concurrently. Then you can use your previous priority date for the new application. For your previous priority date came from NIW application, and your new application is EB1. So you can use your previous priority date for second application. All right, now we're going to the example number 4. An applicant who applied for adjustment of status based on a pending or approved special immigrant petition and now wishes to adjust based on a subsequently filed family or employment-based petition. So this is, I said, let's say you applied for adjustment of status based on a approved special immigrant petition. There's a lot of special immigrant petition. I'm not going that deep into that topic today because that's not the topic today. But let's say you have an approved special immigrant petition, and later you want to apply for a employment-based or family-based category green card, and you can port your previous priority date from a special immigrant petitions. That's a fourth example. Next slide, please. This is the last example. An applicant who applied for adjustment of status based on an approved or pending immigrant petition, but is now a diversity visa program lottery winner. So let's say you applied for employment-based or family-based or a special immigrant category petition, you got approved and you have a priority date, and now you're a DV lottery winner. You can use your previous priority date for this DV lottery winner application. So that's another example. So these are the examples so that you understand what I'm trying to explain. Next slide, please. All right. So in which situation you are eligible to apply for porting or retaining your previous priority date? So there are some requirements, and I'm trying to explain as much as possible. Of course, I tell that to everyone that the purpose of this YouTube video is to make things easy for you to understand. So this is not a legal advice. We cannot explain everything here. It's not possible. I try my best, but sometimes it's not possible. So I hope you understand these things. And if you have any question, feel free to reach out to us. I'll try my best to help you later. So number one eligibility criteria is continuing eligibility to adjust status. There must be no break in the continuity of the applicant's underlying eligibility to adjust prior to submitting the transfer request. The date, let me explain the first sentence first. So let's say you have a approved PARM application and you have an approved I-140 application, and it's been, let's say, 6 years, you're waiting, and now you want to apply for a NIW application. Yes, you can do it, and you can port your previous priority date to this NIW application-based adjustment of status. However, the continuity of your previous PARM-based I-140 must be established, meaning neither you abandon the previous PARM-based application, nor your employer withdraw the PARM-based application. So if the employer withdraws your PARM-based application, then it is gone. Or if you voluntarily withdraw yourself from that application, that's also gone. So you have to maintain the continuity of your previous priority date. Otherwise, you cannot port it. The next sentence is, the date the transfer request is received is the controlling date for determining whether the eligibility continued, not the date the actual transfer request is reviewed or granted. Meaning, let's say you are applying for porting or retaining your previous priority date on January 1, 2025. So that date is the controlling date. The USCIS will see whether you have continuity of the previous application until January 1, 2025. However, after you submit your application on January 1, 2025, USCIS is going to adjudicate your application or review your application in April 1, 2025, 4 months after you submitted your case. If you have discontinuity after you submit your request for porting or getting back your previous priority date, that is okay. If you break continuity after January 1, 2025, that is okay, because the controlling date is January 1, not the April 1. The summary of this eligibility is you must maintain the continuity. And every application has their own rules and regulations. I'm not going that deep into this topic. So let's say family-based application has their own rules for continuing eligibility. Employment-based has their own rules for continuity. Special immigrant petitions have their own rules for continuity. You have to maintain the rules applicable to your field, your original petition. So that's also another thing to know. That's why this topic is very complex, because it comes with so many different rules and regulations in one place. You have to maintain everything. Otherwise, you'll not be eligible to port or retain your previous priority date. Next slide, please. All right. So the second eligibility requirement is continuing pendency of the adjustment application. An adjustment of status cannot be transferred from one basis to another if there are any breaks in the continuity of the application, including if the applicant chooses to withdraw the application or the application is denied because the applicant failed to appear for a scheduled interview without sufficient jurisdiction. I explained the situation. So meaning, you have to have the continuing pendency of the previous application. neither your employer, who is the main petitioner, let's say they cancel the application, they withdraw the application, or let's say there was an interview scheduled and you did not show up. So if you do not show up, and there are some other ways to withdraw the application. So I'm not going that deep again. It's very difficult not to go deep. So let's say you have a pending I-485 application. You do not have a travel document, and but you traveled outside of the United States without a travel document. That will deem that you voluntarily withdraw your I-485 application. You had no idea about this. You actually did not withdraw by yourself, but you traveled while you did not have a travel document, while your I-485 was pending. That's a voluntary withdrawal. And if you have this kind of discontinuity, then you cannot port the previous priority date. This is crazy. So please pay attention to every single detail of these matters. Another point is, a transfer cannot be granted once a final decision has been made on an adjustment application, whether granted, denied, or withdrawn, even if USCIS reopens or reconsiders the final decision. What it means is, let's say you applied for a NIW application 10 years ago, and let's say EB1 application 10 years ago, and your adjustment of status application has been adjudicated. USCIS denied your application, and now you have another NIW or EB1 or family-based application, and you want to port that previous priority date. You cannot do that because that case has been denied by USCIS. Even after denial, let's say you requested to AAO, Administrative Appeal Office, for reopen or reconsider, and the reopen and reconsider application is still pending, you cannot port your priority date because USCIS denied your application. So this is another very serious matter. A lot of people, they think, oh, my case has been reopened and reconsider. Why I cannot port my previous priority date? Because it has been denied. Next slide, please. All right, third, eligibility for substitute category. This could arise when the applicant is transferring from a basis that is exempt from certain inadmissibility grounds or adjustment bars to a basis that is not exempt from the same inadmissibility grounds or bars to the adjustment. What it means is, so let's say you applied for a family-based petition, meaning let's say you are married to a US citizen, and your US citizen spouse applied for a family-based green card application. I-130 was approved. However, you had some unauthorized work in the United States. So under family-based application, especially when you are married to a US citizen, when your immediate family member applies for you, this unauthorized work to United States is exempt. It's not a inadmissibility grounds. However, later you say that, hey, I'm going to apply for NIW, and I'm going to port my previous priority date from my family-based application. But the problem is that unauthorized work, it is a ground for inadmissibility under employment-based categories. So if you have a ground for inadmissibility in the previous category that was exempt, however, it's not exempt in the second category, then you cannot port, because porting priority date comes with all the rules and regulations of the previous application. So even though if you could maintain your previous application, you would get green card because your inadmissibility grounds were exempt for family-based application. It is not exempt in the employment-based categories. Therefore, you cannot port your or retain your previous priority date in the second category. So what it means is you have to have eligibility for substitute categories too. Next slide, please. I know it's going very difficult discussion, and I totally understand your position, but please, you need to know all these things. Otherwise, you may do mistakes. So visa immediately available. That's another important thing. When an applicant requests a transfer of the adjustment application from one basis to another, the priority date must be current for the category the applicant wishes to use. In order to transfer an adjustment application to a new basis involving a preference classification, the applicant must be the beneficiary of a pending or approved visa petition which has a visa available. All it means is, so let's say you apply, again, example, let's say you applied for NIW in 2010 and your priority date is January 1, 2010. And then since then you have been waiting for a long time because of some reason. And now you're applying for EB1, and then you wanna retain your previous priority date, January 1, 2010. That priority date, January 1, 2010, must be present, must be current in the visa bulletin. If it is not current, then you cannot retain, you cannot port your previous priority date. You have to wait until that January 10 is current in the visa bulletin. Only then you can apply for porting or retaining. Next slide, please. Exercise of discretion. This is, so, after all this discussion, after meeting all the requirements, it is not guaranteed that your application will be approved. It is the discretion of the USCIS officer. Whether to grant or deny a transfer request is a matter of discretion. Except for simple transfer between the first three employment-based categories, the adjustment applicant should not assume that the transfer request will be automatically granted. All it means is, the first three employment-based categories, EB1, EB2, EB3, it is kind of, it's not guaranteed, but it's more likely that your request for porting would be approved. There's kind of like a less discretionary power because this is still employment-based categories. Most of the inadmissibility requirements and everything is pretty similarly applicable to all three categories. So it's more likely that your porting request would be approved. However, if you switch from categories like family-based to employment-based, or employment-based to family-based, or special immigrant situation or other thing, please do not assume that it will be automatically granted. There is no guarantee. It's the discretionary power of USCIS officers, and they see many different factors to see whether your porting request will be approved or not. So please do not take it as granted. Okay, next slide, please. Other eligibility considerations. So this is another complex thing. I'm not going that deep because I know it will be very complex, but let me tell you simply as I can do. So transfer to INA 245I as new underlying basis for adjustment. So if an applicant initially filed for adjustment under INA 245I and paid the required additional $1,000 fee, then the applicant need not pay again when requesting a transfer as long as continuing of eligibility is maintained during the transfer. However, this is the important part. However, if the applicant's initial adjustment of the application was not under the provision of INA 245I, and the applicant is now seeking a transfer to a basis which qualifies under INA 245I, then the applicant must pay the additional $1,000 fee and file supplement A to form I-485 for adjustment of status. I know it's very confusing, and I do not want to really talk about this I-485I, I-485A discussion. It's a totally different discussion, but meaning if you applied for something I-485 under I-485I before and paid the additional $1,000 fee and in the supplement A, then if you go for I-485A application, then you do not need to pay the additional fee and submit I-485 supplement J application. On the other hand, if you do the opposite thing, then you cannot port your priority date kind of things. Next slide, please. All right, the special programs containing filing deadlines. Certain programs require that an applicant apply for adjustment of status by a given statutory deadline. In order to transfer the basis of the adjustment application to one of these special programs, the applicant would have to make the request no later than the filing deadline of the special program. Meaning, if your previous application had a deadline, you have to maintain the deadline anyway. If the deadline passes, you cannot port your priority date, port or retain your priority date. Again, so that was our next slide, please. Yeah, so that was the last slide for our discussion today. There's like a second part I'm going to talk in next Monday. And if you have any question about the first part or second part, you can ask me anytime. I'll try my best to answer it properly. But again, it's a very complex topic, and I'm sorry that there's no better way to explain it. Back to you, Urchita.
Thank you so much, Mr. Mahajan, for your insightful session, and I'm sure our audience have enjoyed it thoroughly. Now, we would like to answer some questions that we have received. Our initial question is from Mr. Rodoy Hassan. His question is, how can I obtain AU or T visa if I am a victim of crime or human trafficking in the USA?
So URT visa has their own requirement. It's a long discussion. You have to meet the certain requirement. I have some videos. I actually did some previous presentation on U visa, T visa, pretty much everything. So I advise you to go to our YouTube channel and see that video and see if you qualify for that. Just because you are a victim of a crime doesn't mean you automatically qualify for those things. Every visa category has their own requirements, so you have to meet those requirements. I'm not going that deep in this question because I have a whole video about this topic. So I advise you to go and watch that video. You have a better idea.
Thank you so much. Our second question is from Mr. Fajlur Rahman. I have a B1 V2 visa and will soon marry a US citizen in the USA. After our marriage, when can my wife apply for my green card, and what's the typical processing time for obtaining a green card?
So you can, if you come to America under B1 B2 visa, your wife, your US citizen wife, can apply for you after 90 days of your arrival to United States. It doesn't mean that you guys cannot get married. You can get married the second day. Let's say you're coming to America under B1 B2 today, and tomorrow you guys can get married. That's okay. There's no problem. But she will be able to apply for you, meaning she'll be able to submit I-130, I-485, and other forms after 90 days of your arrival to United States. And if she's a US citizen, usually it's a shorter process. It will take around 1 year to 18 months. But if she's a permanent resident, then it may take a little longer. Again, it may be like 18 months to 2 years, sometimes even longer. So depending on where you live, what is her status, and what is her income level, there's many factors. But in general, for US citizens, 12 to 18 months, and for long-term permanent resident LPR, let's say 18 to 24 months.
Thank you, Mr. Mahajan. I hope you got your answer, Mr. Rahman. Our third question is from Mr. Bozrul Huda. I currently live in Bahrain with a residence permit. If I marry in the USA, then do I need to wait in Bahrain for green card approval, or can I stay legally in the USA with my wife until my green card is approved?
So you're living in Bahrain. So if you have a US visit visa or any kind of visa, then yes, you can come to America and she can apply. She can submit the marriage visa application here in America. There's no problem. And again, it depends on whether she's a US citizen or permanent resident. But if you do not have a US visa, then either you have to stay in Bahrain or you have to go back to your home country. I'm assuming you're from Bangladesh. So in that case, you can stay in Bahrain or you can go back to Bangladesh, and the process would be very similar. I think the US Embassy in Bahrain will be a little faster than US Embassy in Bangladesh because of many reasons. So I think it would be better for you if you stay in Bahrain. But yeah, that's the answer. So if you have a US visit visa, you can come to America and apply green card here in America. If not, then your spouse needs to apply, and either you have to be in Bahrain or Bangladesh.
Thank you, Mr. Mahajan. Our next question is from Muhammad Arafat Mia. He has two questions. His initial question is, my daughter was born in the USA. My daughter has been living and studying in Malaysia for many years and is now 21 years old. Can she apply for a family immigration visa for her parents from Malaysia?
Yes, the short answer is yes. However, there's one small caveat here. So since she doesn't live here in America, sometimes what USCIS officers say is that you US citizen, you do not live in America. How do you want to bring your parents here? Because when a US citizen child wants to apply for parents, he or she needs to say that I'm going to bring my parents here. Since she doesn't live in America, it's difficult to establish that part. So what I advise that first she come to America, because she's a US citizen, she can easily come to America. She gets a job or education or something in America, have an address, American address, like rent an apartment or home, and then she applies for parents. It would be easier and it would be faster process.
Thank you, Mr. Mahajan. Mr. Mia's second question is, can your US firm assist my daughter in paying house rent or electricity?
No, we are a law firm. We can only help with immigration like a legal process. We cannot help anybody renting apartment, paying for apartment bill or electric bill or anything. We cannot do that.
Thank you, Mr. Mahajan. We have another question from the same client. That is, I plan to shift from B1, B2 to F1 status within the USA using premium processing. If USCIS denies my status change, will my B1, B2 visa automatically void? He has a note that I hold a 5-year multiple entry B1, B2 visa currently.
No. If you come to America under B1, B2 visa, and then you get admission to university, apply for change of status, either premium process or regular process, doesn't matter. If you apply for change of status to go to F1, and if your F1 application is denied, you will still have your B1, B2 application. It's not denied or void. It's not the case. However, USCIS has right to cancel your B1, B2 application. They have right to deny your application. That's a different thing. But just because you applied for a F1 visa, it doesn't mean that your B1, B2 application will be automatically cancelled.
With that, our question and answer session ends. Thank you, Mr. Mahajan, for answering all the questions. Thank you, everyone, for participating. And thank you, Mr. Mahajan, again for your valuable time. Before we wrap up, we would like to give a quick glance on the major immigration news of this week.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 4 latest developments in the immigration arena. Let's start with the headlines. USCIS mandates Form I-693 submission with green card applications. USCIS reaches fiscal year 2025 H-1B visa cap. Record removals in fiscal year 2024. New immigration options for families of deceased U.S. government employees. Let's get into details. USCIS now requires Form I-693 medical exam results to be submitted with Form I-485 or green card application. Missing Form I-693 may lead to rejection. Applicants should plan ahead, complete the medical exam with approved doctors, and include the sealed results with their application. Next up, USCIS has filed the fiscal year 2025 H-1B cap of 65,000 regular and 20,000 master's cap visas. With the new lottery system, applications dropped to 470,342 from 758,994 in fiscal year 2024, with 29% selected. No more lotteries will be held, but cap-exempt petitions remain open. Employers should prepare for fiscal year 2026 and check USCIS's H-1B cap season page for updates. Moving on, DHS reported record removals in fiscal year 2024, the highest since 2010. Following President Biden's June 4 proclamation on southern border entry, over 640 repatriation flights were conducted to 155+ countries, reducing border patrol encounters by 55%. DHS continues to expand removal efforts to enforce immigration laws. Finally, DHS has introduced new categories for surviving spouses and children of U.S. government employees who died abroad, enabling eligible family members to obtain permanent resident status under recent laws. Key changes include 12 new classifications like SS1 or Surviving Spousal Child and GS1 or Family of Certain Visa Holders. The statuses grant lawful permanent residency and work authorization.